Good afternoon again, everyone. This presentation is about work anywhere schemes. Now, this started as work from home, but has come to embrace any other place where work can be done outside the workplace. As with the rest of the world, in order to contain the spread of COVID-19, employers and workers in the Philippines shifted to a work from home setup. Now, with the new normal, there has been an emergence of other venues where work can be conducted. That's why this presentation is called Work Anywhere. Another term is remote work. And then an alternative is a combination of both on-site and off-site work called hybrid work. Clamor for work anywhere schemes, it may be driven by the need to save on expenses, transportation, food, or meals, especially considering the rapid rise of prices, the rapid inflation this year. And also, the Philippines, Metro Manila, has a notorious heavy traffic problem. Other causes, workers preferring work anywhere schemes is more exercise, improvement on well-being, better work-life balance with little to no commuting, travel. And then a majority found themselves highly effective in work. And lastly, to eliminate close contacts in case of surges. However, there are those against continuation of work anywhere schemes. For example, women workers. There is a stronger blurring of work time and home time, exposure to a wide range of vulnerabilities, multiple burden for child rearing, family raising, versus duties and responsibilities in the work. And then a majority of employees also missed working in the office, at least part-time. Beginning March 2022, the previous administration began steps towards on-site work. Ecozone locators, those employers inside export processing zones. On-site work is a requirement for ecozone locators to enjoy tax incentives. Tax incentives such as income tax holiday without having to pay any income tax for a certain period of time. Not only did the workers, those in the IT, information technology, BPM, business process management, BPOs, call centers, not only the workers, but also the employers themselves and the government agency in charge of ecozones requested that the government reconsider the decision. The government wanted these employers to make a choice between continued tax incentives, but workers are working on site, versus continued work from home, but the employers have to give up their tax incentives. One employer waived its tax incentives just to allow its workers to continue working from home or through other work arrangements. The current administration extended work from home for those employers I mentioned earlier until the end of this year. And then the employers concerned were also allowed to transfer their registration to another agency, so they would not be subject to the requirement under the tax code of on-site work as a condition for tax incentives. And then the Department of Labor and Employment, DOLE, also issued new implementing rules and regulations to implement the Telecommuting Act, which I will discuss in detail. The purpose of the amendment is to encourage work anywhere schemes. Is there a right to work anywhere in the Philippines? The Constitution lays down policies recognizing labor as a primary social economic force, protect the rights of workers, and promote their welfare. The state shall afford full protection to labor and the right to humane conditions of work. Admittedly, there is no right to work anywhere. But the policies I mentioned, especially right to humane conditions of work, can evolve to support the existence of a right to work anywhere. Constitutions must evolve to cover not only the present but also future circumstances. The Telecommuting Act became law in 2018. Telecommuting is defined as a work arrangement that allows an employee in the private sector. There is a separate set of guidelines for the public sector I will discuss shortly, allowing this employee to work from an alternative workplace with the use of telecommunication and or computer technologies. The definition of alternative workplace: employees' residence, co-working spaces, or other spaces that allow for mobile working. So in short, anywhere. On a voluntary basis, meaning a worker cannot invoke as a matter of right a telecommuting arrangement. The terms and conditions shall not be less than the minimum labor standard set by law and shall not diminish or impair the terms and conditions in any applicable company policy or practice, individual contract, or collective bargaining agreement. Now, the facilities, equipment, and supplies necessary to implement this setup and to allow the performance of work are considered ordinary and necessary costs of the business of the employer. The revised implementing rules do not state expressly that the employer shall pay these costs. Nor is there a rule on payment of utilities used for non-work purposes. My monthly internet subscription is 1,499 pesos per month. No computation in the law which part of that will be used to pay for internet used in work and which would not be paid by the employer because those are considered for leisure. If there are differences, they shall be treated as grievances. Dialogue or consultation is the primary mode of resolution. If unresolved, then the dispute, the grievance, shall be referred to the DOLE regional or field office, which has jurisdiction over the regular or the alternative workplace. And then the parties may also submit to voluntary arbitration. Employers shall also keep the records for at least 3 years. The term is at least 3 years, at least, meaning essentially forever. And then this one is new. The employer must notify the DOLE of the implementation of telecommuting to include all branches, satellite offices, or similar operational units. Meanwhile, for government employees, the term is flexiplace. The policy lays down 3 types, but I will focus on work from home and work from another fixed place. Middle example, work from agency, satellite office. That is not really work anywhere because arguably the agency, satellite office belongs to the agency, the employer. Contract of service and job order workers are not covered because there is no employer-employee relationship between them and the government agency, body, office. For adoption of work from home, there are 2. 1, mutually agreed upon. The assigned tasks can be accomplished outside the office. 2, the tasks cannot be accomplished at the office, satellite office, or another fixed place during an outbreak of a severe infectious disease and or a natural or man-made calamity, and their place of assignment is located within 1 kilometer radius from where infected/suspected patients and public health workers and other frontline workers are regularly exposed to infectious diseases, and a calamity-stricken area. Work from another fixed place. Tasks can be accomplished outside the office other than at their home residence or satellite office. The concerned officials or employees shall request approval. Again, not as a matter of right. The second case in which work from another fixed place is possible, government officials and employees whose tasks cannot be accomplished outside the office and are stranded at a place away from their home or satellite office may be allowed, provided that the agency has assigned alternative tasks. And then another example, government officials or employees who are stranded due to quarantine protocols, unavailability of transportation, or inaccessible road. May, again, voluntary, not as a matter of right. Now, work from home, work from another fixed place, they are not entitled to compensatory overtime credit/overtime pay. Health/psychosocial interventions. And then reasonable expenses, the agency may defray them when there is a work from home arrangement due to emergence of outbreak and or the occurrence of calamities. Compare this in the private sector where reasonable expenses are considered the ordinary and necessary costs of the employer. Challenges, work anywhere schemes are purely voluntary, not a right. I keep stressing that. The use of the term employee presupposes existence of employer-employee relationships in the Telecommuting Act for private sector. For the public sector, contract of service and job order workers are not included. Not all jobs, of course, can be covered because of their nature. Grocery employees, health workers, transportation, police, fire, these cannot be covered by work from home, work anywhere arrangements. Work anywhere schemes are effective only for certain jobs. And then the feelings of isolation, working longer hours, the blurring of the lines between work and family life, hence requiring the need for clear ground rules when workers should be expected to be available for work and when they should be allowed to rest. Now, one of these rules is the right to disconnect. Another issue is the inspection of compliance with labor laws. Can the DOLE or the Civil Service Commission legally visit homes in order to inspect compliance with labor laws, to check on working conditions? And then, where will their employment records be kept? Another challenge is the required technology. One of the challenges in the Philippines was the unstable internet connection. The Philippines has had low internet speeds compared to the rest of Asia. And then, how will the cost be divided? Lastly, trust in work anywhere schemes where managers may not trust that their employees under work from home or work anywhere arrangements are indeed working. I'd like to end with this quote from my YouTube video, my vlog Emir's BTIN, on the Bill of Rights. New rights emerge as people clamor for them. Thank you and mabuhay.